Attorney Laura Anthony, founding partner of Legal and Compliance, a full-service corporate securities and business transactions law firm. Today is the continuation in a LawCast series talking about Regulation A. Both Tier 1 and Tier 2 issuers must file summary information after the termination or completion of their Regulation A offering. A Tier 1 company will need to file certain information about the Regulation A offering, including information on sales and the termination of sales on a Form 1Z exit report, no later than 30 calendar days after termination or completion of the offering. Tier 1 issuers otherwise do not have any ongoing reporting requirements. Tier 2 companies are also required to file certain offering termination information and would have the choice of using Form 1Z or including the information in their first annual report on Form 1K. In addition to the offering summary information, Tier 2 issuers are required to submit ongoing reports, including an annual report on Form 1K, a semi-annual report on Form 1SA, current event reports on Form 1U, and notice of suspension of ongoing reporting obligations on Form 1Z. The ongoing reporting for Tier 2 companies is less demanding than the reporting requirements under the Securities Exchange Act. In particular, there are fewer 1K items and only the semi-annual 1SA rather than quarterly 10Qs, and fewer events triggering Form 1U compared to a Form 8K. However, as I've mentioned in other LawCasts in this series, in order to maintain current information for purposes of Rule 144, some issuers elect to file quarterly information by filing a quarterly report using the Form 1U during those periods in which they are not otherwise required to file an annual or semi-annual report. The annual Form 1K must be filed within 120 calendar days of the end of the fiscal year. The semi-annual Form 1SA must be filed within 90 calendar days after the end of the semi-annual period. The current report on Form 1U must be filed within 4 business days of the triggering event. Successor issuers, such as following a merger, must continue to file the ongoing reports. The rules also provide for a suspension of reporting obligations for a Reg A reporting company. Termination is accomplished by filing a Form 1Z and requires that the company be current in its reporting up to that time, have fewer than 300 shareholders of record, and have no ongoing offers or sales in reliance on a Regulation A offering statement. Also, as discussed in prior LawCasts in this series, a Tier 2 company that has used an S1 format for its Form 1A can file a Form 8A concurrently with the qualification of its offering circular and become subject to the full Exchange Act reporting requirements. In that case, they do not report under Regulation A, but rather report under the Exchange Act. Also, a Regulation A reporting company may file a Form 10, which would then make the company subject to the full SEC reporting requirements and terminate the lighter Regulation A reporting. Regulation A reports qualify as the type of information a market maker would need to support the filing of a 15C211 application. Accordingly, an issuer that completes a Tier 2 offering could proceed to engage a market maker to file a 15C211 application and trade on the OTC markets. I'm Securities Attorney Laura Anthony, founding partner of Legal and Compliance and producer of LawCast. Should you have any questions about today's topic, please visit securitieslawblog.com and lawcast.com or contact me directly. Inquiries of a technical nature are always encouraged.